be set aside and bond be reissued.
All right, well, the warrant will be set aside. Bond reissued.
In regards to sentencing, Your Honor, I have gone to the pre-sentence investigation report of my client. It is not factually accurate to its contents.
Oh.
Referring to page 1 of the report, indicating pending charges. The second charge counted to 34th District Court. My client indicated while she was out on bond, that matter was resolved. So that's not accurately reported.
Okay. Well, I'll write resolved with a question mark after it. Okay.
In regards to page 5 of the pre-sentence investigation report, adult history, first conviction indicates November 4th, 2011 was the date of the offense. The date of resolution was 12/6/2011 by way of plea. My client indicates that she did not receive this particular charge under the 34th District Court. She is unaware of this particular conviction. We ask that be removed from the report.
I'll just simply indicate defendant does not acknowledge.
Very well. Otherwise, Your Honor, there are no other corrections, additions, or deletions to be made to the report. The defense respectfully requests that the court abide by the sentencing agreement. Oh, I'm sorry, there is one.
Well, yeah, there's a credit issue probably. When was she picked up on the warrant?
She was picked up, I do believe, Friday on the warrant.
The day I issued it?
That's correct.
So she got another 7 days credit.
That is correct. That would bring the total up to 76 days of jail credit.
Okay.
Now there are no corrections, additions, or deletions to be made to the report. And the defense respectfully requests that the court abide by the sentencing agreement of 3 years probation, first 6 months in the Wayne County Jail with no objection to work release.
So the guidelines are pegged at 43 to 86 in the pre-sentence. Is that right?
No, they are absolutely incorrect.
Okay.
Last calculation, we had the guidelines started at 24 months.
Started at 24?
They were started at 24 months.
Okay. On child abuse?
On child abuse second, yes.
Yes.
What's the range that you got? 24 to something? I thought it was 12 to 24 actually, but okay. What do you think it is?
If I may just check my phone for the actual guidelines grid. The court indicates that the court was under the impression it was 12 to 24 months. I believe that that is correct.
And they did, they dropped the cap.
Well, okay.
Or are you saying a different?
Or 19 to 38, or was that for, that's for manslaughter, I think.
That's
Yes,
correct.
19 to 38, I believe, is the manslaughter.
Okay. I seem to remember writing down 12 to 24 somewhere. Well, all right, I guess we can agree that the way they're scored here is wrong.
That would be correct.
All right. All right. Is there anybody here that is speaking on behalf of the victim?
I don't believe anyone's speaking, but let me just confirm that. Okay. No, Your Honor. The grandmother is present in court. She did, though, make a victim impact statement in the pre-sentence report.
She did.
And she would ask that, the court, as you probably already have, read it and adopt that as her position. She doesn't have anything addition to add to her statement to the pre-sentence investigator at this time.
All right. Ms. Johnson, I'm going to give you a chance to address the court if there's anything you'd like to say. I'd like you to, first of all, explain to us why you were not here last Friday. which was your assigned sentence date?
I was trying to get all of the things that I needed in order to be in jail, you know, how
I see.
I'm allowed to have the work release. I recently just got a job and I was trying to I had to prove my identity, and like a whole bunch of just messed up things happened that I had to try and do, and I was actually downtown trying to do it. And then it took a long time, and I was in contact with my lawyer, and I just didn't make it in time. I didn't even get to finish doing the things that I was trying to do to bring to you.
Why didn't you call us and tell us that you needed a little extra time, or call your lawyer and
I was
ask
in
him to?
contact with my lawyer the whole time.
Well, that may be, but he was not under the impression that you were unable to be here last Friday because of a legitimate need.
Well, the first time that we made contact on Friday, I let him know that I was at the main Secretary of State downtown in the Cadillac building. I let him know that I was there trying to prove my identity, and then it was kind of just text messages back and forth, him letting me know that I needed to be here, me letting him know that I was trying to get here as fast as I could. And then I believe it was 2 o'clock was when I actually made it to downtown, and he told me that the warrant was already issued.
Yeah. Well, you put a lot of people to a lot of trouble. I don't know whether you came in and turned yourself in. How did you find yourself in custody? What happened?
Dearborn picked me up.
Oh, they
from
did
my
pick
home.
you up. You didn't just come here to the court and present
No,
yourself.
He told me to turn myself in on Monday. I went home, and Dearborn came and knocked on the door.
Before you got a chance to turn yourself in.
Correct.
Mr. Longstreet, anything you'd like to say on this?
I'd ask that the court forgive my client for it.
So, I think part of the original sentence agreement was that we would be okay with work release if you could provide documentation of the fact that you have a job, a full-time documentable job. Do you have any of that information?
She does not, Your Honor. She wasn't
Okay.
able to say.
Well, there'll be no work release.
Very well.
And I'm going to add 30 days to your jail sentence. All right. Your sentence is as follows. You're placed on probation for a period of 3 years as originally agreed upon. I'm going to give you the first 11 months in the Wayne County Jail instead of the 10 months. In my view, you have disenfranchised yourself from the right to enforce this sentence agreement by failing to show up on the original date of your sentence. And other terms and conditions that apply to your sentence are as follows. No early release. I'm going to put that on the judgment of sentence. But upon release, you'll continue to be under the court's supervision for a period of time. You will get 76 days credit against your 11-month sentence. You are not to use or possess any alcoholic beverages or other intoxicants during your term of probation. No drug use. Do not be in possession of any illegal drugs or be in the company of anybody that you know possesses or sells illegal drugs. You are going to undergo a substance abuse assessment. You are going to be tested periodically for substance abuse. If you test positive, you'll be in violation of your probation, and you could be in very serious trouble. You are to take medication only as prescribed by a licensed physician who is not under indictment. And so if you test positive for any drugs, you better have a prescription for those drugs by a licensed physician who's not under indictment. I'm also ordering that you undergo a psychological evaluation and a complete mental health, domestic violence, batterer intervention, or other recommended treatment following the assessment that I've just indicated. I'm also ordering that you complete parenting classes. Okay, otherwise, I think these orders are largely financial.
Your Honor, may the people request that the court also require her to follow the recommendations from Child Protective Services. And-
Okay, is there a parallel Child Protective Service action
Yes.
pending in juvenile? Okay.
Yes, there is. And that, so we would ask for that, as well as a condition that she do not have contact with the children until she's authorized by that court to have contact with her children.
I
Okay,
believe she's under, I think she has supervised visits at this point. I don't think it's necessary for the court to intervene in the.
okay. I won't order anything more than what they've ordered, but I'll adopt their order. No unsupervised visitation. He says that she can get probably so. And you'll follow to the letter the order entered by the family court judge that has control over your case. So that if you violate that order, you'll not only be in trouble on that docket, you'll be in violation of your probation order with me. And finally, you're to pay $68 in state court costs, a $130 crime victims assessment fee, a supervision fee in the amount of $250. I think you'll be under supervision for not quite 36 months. I'll order $360 in court costs as well. Those latter amounts can be paid over time. Anything further from the people?
Nothing from the people, Your Honor.
Nothing from the defense, thank you, Your Honor.
All right, Ms. Johnson, you have a right to ask the Michigan Court of Appeals to review your plea and sentence in this case. They don't have to, but you have a right to ask. And if you're unable to afford a lawyer will be appointed for you at public expense, and the lawyer will be provided with a copy of a transcript of today's proceedings and anything else out of the court file that the lawyer may need in order to manage your appeal. You're going to be given a form to sign in which you acknowledge receipt of the rights that I just gave you. It is a copy of that form that must be filed with the clerk of this court within 42 days of today's date if you intend to appeal and ask for a court-assigned attorney. You know, it may not have been entirely clear, and it's my fault if it wasn't. When I asked you if there was anything you'd like to say, I then said, first of all, I'd like you to explain why you were not here on your original sentence date, and you did that. Is there anything else you'd like to say about this conviction?
I just want to apologize to my other kids for having to lose a sibling, for me not being a good parent. It's not fair to them to have to suffer.
Okay, fare thee well and good luck.
Thank you.
Thank you.
Oh, Mom.